Thank you so much. Everybody, welcome. This is Erica Sussman, and we are so thrilled to have all of you joining us today for the next in our Consumer Rights for Domestic and Sexual Violence Survivors webinar series. Today's focusing, of course, on bankruptcy and alternatives for survivors. For those of you who are new to CSAJ's work or others who have been working in partnership with us for many years, I just want to provide an overview of CSAJ's mission and vision, and then, of course, introduce you to our incredible faculty. So the Center for Survivor Agency and Justice envisions a world where all people have equal access to physical safety, economic security, and human dignity. And we carry out that vision statement through our mission. CSAJ promotes advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. Before we launch into today's program, I just want to introduce you to my colleagues, Sarah Lee, who is our Director of Research and Programs and will be with us throughout the program today. And also our newest CSAJ addition is Yvette Butler, and she is our Director of Capacity Building and Systems Change, and we are absolutely thrilled to have Yvette with us today and onward. So thank you both. And now I will introduce you to our faculty joining us today, and that is Karen Tjapkes. Karen is a supervising attorney of the Strategic Litigation Unit and directs the Home Ownership Preservation Project at Legal Aid of Western Michigan in Grand Rapids. Legal Aid of Western Michigan's mission is to secure justice and protect the rights of persons unable to obtain and pay for legal services in civil matters by providing legal representation and counsel. And her practice is concentrated on consumer law, housing law, and mortgage litigation. Karen has been an expert advisor with CSAJ for many, many years and has deeply enriched our work throughout our partnership. So deeply grateful for all that you're bringing to the table today, Karen, and throughout the history of our work together. So without further ado, I will hand the program over to Sarah, who will provide some framing.
Thank you so much, Erica, and just echoing a welcome to Karen and Yvette and all of you joining us today. So as Erica mentioned, what I'm going to do is just provide a little overview, let you know some announcements we have, and try to help frame this webinar in the context of our guidebook on economic and consumer civil legal advocacy for survivors, which this is a part of. So some of our objectives for today, which Karen will go over in greater depth, is we hope that you're able to walk away a little more familiar with bankruptcy concepts, able to issue spot and identify how bankruptcy might show up in survivors' lives, and some options to addressing debt that survivors face, as well as understanding more about the connection between bankruptcy and family law, and also equipped with unique and innovative practices through your own discussion and through some of what Karen shares. And I'm really thrilled. I know that a lot of you mentioned some of these things when you registered for the webinar, so please take this time to ask us questions, share with us what you're seeing, what you're doing, where you might be struggling, so that we can engage in that group conversation with you. So while I do a few more announcements, if I could ask everyone who's joined us, which is an amazing 80 people and counting right now, can you introduce yourself? Let us know what organization you're with or where you're coming from, if you feel comfortable doing so. and maybe a question or what brings you here today would be really helpful. Let us know who you are. These are just some things that Karen will cover, some basics, options, again, the intersection between family law and bankruptcy, and also tapping into a focus of ours is really thinking about what this means for our organizations, our communities, and the systems that we encounter and navigate. Before I fully hand it off, just a couple announcements. We do have a second part of this, which is talking about a closely related and yet requires its own time webinar to really dive into student loan, a particular type of debt that survivors face, and really navigating student loans and options. So if you haven't already, please register for that webinar, which will take place at the end of the month on January 30th. And we know that many of you are doing that amazing, cutting-edge, innovative work, and we want to know more about that so we can share it with the field. So if you are doing innovative economic or consumer work in bankruptcy or any other consumer economic issue area, let us know. You can email us. You can go to this link, which I'll share in the chat. But we want to know what you're up to and spotlight and share the good work that you're doing so we can enhance advocacy for this across the country. And so finally, just to provide some framing and tap into some values that we're applying to this training through the guidebook, as well as that inform our objectives for today. You'll see in the resource pod access to some chapters that Karen has written in collaboration with some folks from the National Consumer Law Center. Both on bankruptcy, there's a closely related chapter on foreclosure as well that you can access, and I encourage you to do that. So some things that you'll see today and that really ground our work here is centering this on survivors' lived realities, experiences, and self-defined needs. So we try to do that in the guidebook as well as in the training today through sharing some scenarios and asking questions and really understanding the multiple and complex needs that survivors face. So you'll see that today through this little book icon. Whenever we're grounding work in survivors' experiences, we'll have that icon up on the PowerPoint, and you'll see that the guidebook really works through specific survivor case scenarios to help us really put this in practice. And we encourage you all to kind of share what you're seeing as a way to help us navigate this. We also know that the value of really understanding and having a full sense of how these issues show up for survivors is critical to our ability to help address some of them in partnership with survivors. So we have this magnifying icon throughout the PowerPoint that lets you know that we're asking some specific questions, giving you some thought-provoking questions to consider in your advocacy to help understand how bankruptcy and options might show up and ways you can consider that in your advocacy with survivors. So take a look at that. And then finally, the other really amazing thing in the guidebook is we know that these issues often need to be addressed in unique ways given the safety, privacy, confidentiality, and other complex identities and safety needs that survivors face. So we have this light bulb icon, and throughout the guidebook we really look at what are some concrete practice tips that can be helpful in your advocacy in identifying legal remedies and applying legal and advocacy strategies in this work. So those are just some ways to guide you in linking this presentation with what our guidebook covers and as a reminder for us all as some values and ways that we think about approaching this work. So with that, I'm going to hand it over to our esteemed faculty, Karen, and thank you again for being here and sharing all your goodies with us.
Thank you. Hopefully everybody can hear me okay. I will apologize. I've had a bit of a cold, and so I'm still coughing a little bit, so I will try not to do so into your ears. But if I pause for a moment and something sounds strange, it may just be that. As Sarah mentioned, I've worked with CSAJ for a long time, 9 years, 10 years, a long time, working on these trainings. Most of what I've historically done with CSAJ has been in the foreclosure realm. Excuse me. So doing the bankruptcy presentation and making the move into the bankruptcy space is something new for CSAJ. And so I really do hope that if you have comments or questions, that you do your evaluation at the end, because I think we'd really like to know how you think this goes, since it is kind of our first time. As Sarah said, we do have some objectives for today. She went over them briefly. Basically a lot of today is sort of a crash course in becoming familiar with some bankruptcy concepts, so that when you're working with survivors, you can figure out when bankruptcy might be an option that a survivor should investigate further. And then exploring the connection between bankruptcy and family law. There's considerable overlap, and to try to get folks a little bit comfortable with what that overlap is, and where bankruptcy may be helpful versus where bankruptcy may become problematic in terms of coordinating with your family law cases. And then also to look at, what you all are doing. If there's lessons we can learn from you and things we can share about this intersection. Okay, so bankruptcy basics. And I can tell from my list there's a few of you, and I won't name names, who could probably do this section for me. But this is kind of the crash course in bankruptcy law. So the first thing we're going to do is I just want to get a sense of, even though I recognize some names, where folks are in this space. How are you working with survivors on consumer issues generally? It looks like we've got a lot of people who have a really good grounding as these poll results come in, and are working with survivors on debt-related issues. That's great. That answer wouldn't have been the same 10 years ago. Looks good. I think we've got about all our answers in, maybe? All of our answers in? It looks like we've got them all in. So yeah, it looks like the vast majority are working on these debt issues. So the next question is specifically as to bankruptcy, about if you're working with bankruptcy in your practices. Yeah, but it looks like we've got a few people who are really working in the bankruptcy space, but it does look like the majority of folks either aren't doing a lot of bankruptcy work or do have some space for it within their program, even if they're not doing it personally. So good. Good. Great. Thank you. There it is. I just lost my little arrow guy. So as we know, especially if you've been working with CSAJ, we know that the consumer rights of domestic violence survivors is really important, and that we cannot really address domestic violence without looking at the consumer law effects, the debt, the income, all of those things. And so this is a graphic that the CSAJ staff has developed based upon their research, and the citation to their article is there, about how many survivors of domestic violence report surviving economic abuse, some of the issues then it comes to seeking safety, that they have trouble getting their partners to pay them, for child support and those kind of things, that the effects of the credit, the economic abuse, can lead to substantial difficulties with moving on, with finding employment, with finding housing and those things because of the credit report effects. And then the short-term effects and the long-term effects. So it's really exceptionally important that we look at these issues of economic abuse and develop practices that seek to address them and try to offer solutions and work with folks so that they can both long-term and short-term address the economic abuse as they look at leaving these relationships. So when can bankruptcy be useful? Bankruptcy can stop debt collection harassment. So folks who are getting constant phone calls, who are getting court officers looking for them to serve court paperwork, it can stop all of that harassment. It can stop garnishing wages or the garnishment of a bank account. In some cases, within 90 days of filing, they can actually sometimes recover that money in certain circumstances, which can be obviously very useful, especially if you've got, several thousand in a bank account that's been swiped by a creditor. It can stop a mortgage foreclosure. It can stop repossession of a car or other property or collateral. It can prevent overpayments from governmental agencies from being collected. So say you have somebody who has an SSI overpayment, say the household went over income when they were married, now they need their whole SSI check, but part of it's being used to collect an overpayment. Bankruptcy can be used to stop those overpayments unless there's a fraud element, which is a whole separate discussion. But for most of our clients, they can use bankruptcy for that purpose. It can also avoid liens and some security interests on property. So there's kind of several basic types of bankruptcy that folks file. The most common kind of bankruptcy, and the one that most people kind of think of when they think bankruptcy, is the Chapter 7 bankruptcy, which is a liquidation bankruptcy. And that's kind of where somebody goes to the bankruptcy court and says, okay, bankruptcy court, here's all my information. I have all these debts. Here's my income. Here's my assets. I'd like to make these debts go away. And assuming kind of with, for the most part what they've got on, usually the bankruptcy court can make that happen. There is a test called the means test, which does look at where there are certain higher income debtors that it takes a 6-month snapshot of their income. And if you're over certain limits that are kind of pegged to IRS expenses and that kind of thing, it can make you ineligible for a Chapter 7 bankruptcy and force you into a Chapter 13 bankruptcy. Those of you who are working at legal services organizations, that's never going to be an issue for your clients, because if your clients are eligible for legal services, they're going to be eligible under the means test. It's more upper middle class kind of debtors that are going to run into that means test issue. But a Chapter 7 bankruptcy doesn't have a payment plan. Although you do want to look at, and we're going to talk a little bit about assets, because if they do have some more expensive assets, then the Chapter 7 bankruptcy might involve having to pay some money in or have an asset being sold. The other kind of chapter of bankruptcy that kind of regular folks file is a Chapter 13 bankruptcy. And this is the bankruptcy where they do set up a payment plan. And that payment plan is often used to get up to date or to get caught up on arrears for something that the person wants to keep. So I use Chapter 13 bankruptcies a lot in a mortgage foreclosure context, where my folks got behind on a mortgage, but their income is back into a good place, and we're looking to set up some sort of repayment plan with the mortgage company. And then the bankruptcy court will give us a 3 to 5 year repayment plan to address that situation. There's also a Chapter 12 bankruptcy that's for family farms and fishermen. There's a Chapter 11 bankruptcy, which some of you may have just heard about, that's generally used by businesses or by very wealthy individuals. I just throw those out there in case you've heard those terms. But our discussion today is going to really focus on the Chapter 7 and the Chapter 13 bankruptcies. One thing also to know about bankruptcy is that several years ago, the Congress decided that as a part of the bankruptcy process, that consumers, so regular individuals, need to go through a credit counseling course prior to filing bankruptcy. Those credit counseling courses are available online or by phone. They do often cost a little bit of money, although sometimes that fee will be waived, again, especially for legal services type clients. It's something that has to be done prior to filing bankruptcy. I think there's mixed reviews about how useful that course actually is. I do think most folks, by the time they're ready to look at filing bankruptcy, the information in that course is probably no longer horribly useful. And then there's also a debtor education course that has to be completed after the filing of bankruptcy before you can complete your bankruptcy. All right, so when a bankruptcy is filed, something called the bankruptcy estate is created. And that bankruptcy estate includes basically all the things. So anything that the debtor owns, that the debtor has some sort of right to, all of those things are included in the bankruptcy estate and come into the bankruptcy case unless they're specifically exempt or what's called abandoned by the trustee. That is, that the trustee looks at that thing and says, I don't want to worry about that thing. It's not worth enough for me to bother with. There are what are called exemptions. And so one thing that's really important to make sure folks understand is that because of exemptions, when you file bankruptcy, a lot of times folks are going to come out of that bankruptcy with the things they started with. You know, it's a lot of times you're able to exempt equity in a house up to a certain limit. Most of the things in your house are going to be exempt. So there's a really significant concern among folks that if you file bankruptcy, you're going to just lose everything, and they're going to come to your house and they're going to take, you know, your pots and your pans and your clothing. And that's not true because of the exemptions. I guess an example of what are the federal exemptions. This is kind of where you need to meet a bankruptcy attorney in your state and figure out what this looks like in your state. Some states, excuse me, some states you're only allowed to use federal exemptions, and some states you're only allowed to use state exemptions, and some states you can choose either. So example, I'm in Michigan. In Michigan, we can choose to either use some state exemptions or to use the federal exemptions. So that's something that's useful to know because different states are going to allow you to keep different things. But again, most states, as well as the federal exemptions, do allow for things like, you know, your pots, your pans, your clothing, and that kind of thing. One of the reason that we need to know whether or not property is exempt, and therefore whether or not that property is going to be a part of the bankruptcy estate, is because in a Chapter 7 case, if you have assets or property that are above those exemptions, then the bankruptcy court, usually through a person called the trustee, can look to liquidate those assets. That is, sell them, take the money, and then give the money to the creditors. In a Chapter 13, you don't usually see the sale of the property unless the debtor, that's what the debtor wants. But the debtor then has to pay in the value of that non-exempt property into a Chapter 13 bankruptcy, which can sometimes make the payments quite expensive if they have a lot of non-exempt property. Okay? So it's important to sort of, before you look at filing a bankruptcy, that a qualified attorney goes through these considerations with your survivor about what do they have, what is it worth, and do that planning. And just one note, in a Chapter 7 case, once you're in, the debtor cannot voluntarily dismiss a Chapter 7 case. So you don't want to file a Chapter 7 case without a good investigation and thoughtful process into what are the pros and the cons. Because if there's a mistake that's been made or something we don't know going into a Chapter 7, we can't get out of it easily. Whereas in a Chapter 13 case, the debtor actually can dismiss a Chapter 13 case at any time without having to give a reason. So don't go into a Chapter 7 until you know what you've got. the other thing that happens when you file a bankruptcy case is something called the automatic stay goes into effect. And the automatic stay is usually what folks are looking for when they want to file a bankruptcy, because that automatic stay prohibits most attempts to collect pre-petition debts, whether that's a lawsuit, whether that's a foreclosure, whatever that is, garnishments, whatever. All of that activity has to stop immediately upon the filing of the bankruptcy petition. Now, there are a couple exceptions that go generally to criminal proceedings. The domestic relations proceedings we're going to talk about in a couple minutes about what that looks like. And then if folks file bankruptcies repeatedly throughout a year period, their automatic stay may be limited or may not go into play at all if they've filed too many times. So it's important to know if they've been in bankruptcy court before, and if so, when. So because the creditors can't do anything for the most part once the stay goes into effect upon the filing of the petition, some creditors may ask to call what's lift the stay because they think for some reason they should be able to continue a collection proceeding. The most typical lifting of the stay that I see would be if they filed a bankruptcy, but for some reason something needs to continue. So if I have a debtor who files a Chapter 7 bankruptcy, the Chapter 7 bankruptcy doesn't allow for a payment plan. But if there is a car loan or a house loan, if there's a loan that's attached to a piece of property, for those of you who are lawyers, those secured loans, you have to keep paying on that loan if you want to keep the thing. And in a Chapter 7 bankruptcy where you're not really proposing a payment plan, if you're not paying your payments, you don't get to keep the thing. So that's oftentimes when you see a motion to lift stay. Okay. Some of them do it. Some of them are just like, a Chapter 7 bankruptcy doesn't take that long and they just ride it out. What most people are looking for when they file bankruptcy is what's called the discharge, is the order of discharge. And that's the order that eliminates the legal obligation to pay most or all of the debts. It operates as an injunction, which is, for those of you who are non-lawyers, a court order that says that creditors are not supposed to collect that debt in the future. And violations of the discharge order or the discharge injunction can be punishable by contempt of court. Those kind of proceedings are usually also done in the bankruptcy court. One thing that's important to know about bankruptcy, and this can, as we talk about later, about like how to figure out when to file or if to file, one consideration to think about is that what's included in the bankruptcy date is tied to the petition date. So the date I file my petition or my request for bankruptcy is a critical date, because any debts that I incurred before that petition date will be included in the bankruptcy and will likely be discharged. Any debts I incur after the petition date are not included and will not be discharged. So it can be really important when working with survivors and individuals looking at bankruptcy to think about that petition date and the timing of it. For example, if I know I have a family or a survivor with medical needs and I have surgeries or medical procedures coming up, especially if I don't have great insurance coverage, it may be advisable to look at waiting to file that bankruptcy until that's done with, so that way if there is some medical debt or some bills incurred, that we can include them. Likewise, I often use that opportunity to talk about things like insurance. If I have someone who wants to file bankruptcy who doesn't have car insurance, I 99% of the time will tell them they need to go and get auto insurance coverage before we file that bankruptcy, because if they're in an accident, 2 hours after we file that bankruptcy, none of those bills related to the accident are going to be included in the bankruptcy. you can't file, there's limits on how often you can file bankruptcy. In Chapter 7, you can only file bankruptcy every 8 years. We're going to have a problem then. So something to think about in terms of planning and working through these things is looking at that petition date and understanding what a line in the sand that is. Someone just asked, and this is a good time to point this out, about an issue with getting debt when you're thinking of filing bankruptcy in good faith. That yes, if you are using credit cards and things too close to your bankruptcy filing date, there can be issues of whether that bankruptcy filing is in good faith. Now those kind of debts they're looking more at like luxury goods. You know, do you really need all those new clothes? Did you need that trip to Las Vegas? Versus utility service, where you need utility service. I live in Michigan. It's very cold out. Where it's a non-luxury item that, yes, maybe you didn't pay the bill the month before filing bankruptcy, but it's a very necessary service. You were running up your credit cards with fun stuff right before filing bankruptcy. But that is an important consideration to talk with somebody who's looking at bankruptcy about you know, what credit they're using, if any. Stop using those credit cards. Stop trying to, you know, stop to payday loans, and kind of see where you are at that point. Now, there are certain kinds of debts that are not going to be discharged in bankruptcy. And so this is kind of a brief overview of that. Many tax debts, especially if they're newer tax debts, are not going to be discharged in the bankruptcy. I will caveat any discussion of taxes with, if you are interested in the issue of taxes, we did do a webinar on taxes for survivors in the fall with an amazing, excellent presenter. And so if that's an interest to you, I would encourage you to find that webinar recording and information on the CSAJ website. There is sometimes an issue with debts the debtor fails to include in their bankruptcy filing. Depending on what kind of bankruptcy it is and where you are, sometimes it's a problem and sometimes it's not. Domestic support obligations is the bankruptcy code verbiage for child support and alimony, essentially. It's a little more complicated, but child support and alimony are not dischargeable in bankruptcy. Most fines and penalties owed to governmental agencies are not dischargeable, but again, that does not include an overpayment of benefits. But it could include the fines and penalties that may not be discharged. Student loans are generally not dischargeable unless you can show an undue hardship. Most circuits employ that undue hardship test. I'm not going to talk about student loans because in 2 weeks you're going to have an amazing expert talk about student loans. And so I encourage you to tune back in 2 weeks for Persis' presentation on student loans. But it is important to know that bankruptcy won't generally fix a student loan issue, that's going to require some other options and some other planning. Debts incurred while driving while intoxicated are not dischargeable. A debtor can agree to pay a debt despite the bankruptcy, and that's called a reaffirmation agreement, and then those debts are not dischargeable. And these debts don't require kind of any extra paperwork in the bankruptcy court. They're listed. Everybody knows that these debts are what they are, and they kind of just ride through the bankruptcy and come out the other side intact. Some debts are non-dischargeable, but there might be a question about it. And so these debts, they're required to bring what's called an adversary proceeding under the bankruptcy rules. An adversary proceeding is kind of like a lawsuit underneath the bankruptcy in a bankruptcy court. They actually even get their own case number in the bankruptcy courts. So some of these things are debts incurred by fraud that may not be dischargeable. So say somebody said they were eligible for some sort of financial benefit, lied about their eligibility for that financial benefit. You know, maybe they lied about their income or something, and then the creditor can bring a case in the bankruptcy court and ask for a court determination about whether or not that is dischargeable. There is a provision in the bankruptcy code about that's a special for survivors of both domestic violence as well as other crimes. I think you could use this for, is that if when you file a bankruptcy court, I should back up, when you file a bankruptcy court petition, you file about 20-30 pages of financial disclosures. And a part of that financial disclosure is where do you live and where have you lived for the past several years. Obviously, for some of our survivors, disclosing their address puts them in grave danger. And so there is this provision in the bankruptcy code that if disclosing their address does put them at undue risk of unlawful injury, that they can ask the court to excuse them from providing their address information to the court. There are some districts who have some local procedure for this. Most bankruptcy courts don't, and kind of deal with it on an ad hoc basis. But just so that you know, if that disclosure of address information is a concern for someone you are working with, this provision exists. It's not horribly well known. I don't think it's used a whole lot, but it is there. Okay, so just taking a pause, partly so I can drink my tea and not cough anymore. If you want to kind of give us some information in the chat box about if there are ways that bankruptcy is showing up in your work with survivors, are there some challenges that you're seeing or that you're seeing your survivors seeing in navigating the bankruptcy system? And then you can also throw in, too, if you just had a question about anything I just said that you'd like answered, this might be a good time to do that as well. It says me multiple attendees are typing, but I don't yet know what they're typing. All right, so Erica asked about what strategies I've used to address the address non-disclosure protection. I have to admit that I have yet to have a survivor who has needed that. A lot of the bankruptcies I do are actually to prevent foreclosure, so everyone knows where the house is. And so I have not personally had to use it. I have talked with other advocates in other parts of the country who have, and every so often I'll actually pull legal services bankruptcy attorneys to just sort of see what's happening at the bankruptcy court level. And so I do know some people are doing it and having to address that issue. I do have a comment. Many of my participants have already filed bankruptcy without knowing the full impact and are left with many credit issues. And yeah, obviously filing bankruptcy it's a huge thing, and it has some credit ramifications. There are some people who file bankruptcy. It's an overwhelming process, and so even if they have a good attorney advising them, it can be hard to understand what life on the other side is looking like, and how do we go about rebuilding our credit or dealing with things after the bankruptcy. How will bankruptcy go if they're married? And we'll talk about this a little bit more. But it's something to consider. I've had, sometimes folks should file married. There's a thing called that you can marry, you can file a joint petition if you're married, and sometimes that's advisable. Sometimes it's not. Sometimes it may be financially advisable, but not advisable given all the safety considerations. But one spouse cannot force another spouse to file bankruptcy. Asked about fees. For folks who are filing a Chapter 7 bankruptcy, there is a provision in the code that the Chapter 7 bankruptcy fee can be waived within the discretion of the bankruptcy court if the debtor is under 150% of poverty. so there is that provision. A Chapter 13 fee can never be waived, but you can fold it into your Chapter 13 payment plan. And the Chapter 7 fee can also be set up on a payment plan with 4 installments. But it is a good chunk of money, and I know that is a barrier for folks, both the filing fee as well as the credit counseling and debtor education fees on top of that. Yes, comes up as an issue for housing, absolutely. Bankruptcy and housing are not always good bedfellows. There's a lot of information out there about bankruptcy and a lot of landlords who believe certain things about a bankruptcy that are just not accurate. And that is a whole soapbox for me, Tempest. I'll probably avoid this soapbox because I could spend a whole hour there. Yep. A romance scam.
Just to interject,
yep.
while you
Go ahead.
Sorry, while you're
Yeah.
responding to some of these, because of the questions about housing and how long some of these issues can ask and how triggering some of it can be, I would recommend folks, and I can share links, look at some of, for example, the introduction chapter of our guidebook, and credit advocacy generally can help folks think about ways to talk about some of these really tough issues and how to tease through them and how they might bring up other issues and kind of bringing it into a broader context. So I just wanted to mention that, and then point to Caitlin's comment, because I had a similar question about, for example, when, for example, if they've filed their income incorrectly. You were talking about that earlier, but we know that coercive and economic abuse happens all the time. So how do you kind of navigate that when some of those things may have happened, but unbeknownst to or under duress from a survivor?
Yeah. There's a question about how long it stays on the credit report. It does stay for about 10 years on a credit report, so it is there a while. But those who do credit report work and who've studied those algorithms that develop the score will generally tell you that bankruptcy, as well as all the information on the credit report, the older it is, the less it's weighted into the credit score. Mortgage underwriting right now, because that's usually the question most folks really want answered, is, can I get a mortgage? Mortgages for a Fannie and Freddie, so a prime mortgage or a conforming mortgage, the wait time there is about 5 years after Chapter 7 bankruptcy. Other credit cards will give to you right after bankruptcy. I have folks who file their petition and a week later are getting solicitations for new car loans and new credit cards because those companies know that you can't file a bankruptcy again right away. And so from where they sit, you're an excellent credit risk because they know they'll be able to collect against you. And so then after filing bankruptcy is the time to talk with your clients, with your debtors and your survivors about establishing good credit habits and not taking out a 24% interest car loan, but maybe doing like a credit card that's just for gas stations, and then you charge your $50 in gas and pay it off each month. So you're establishing a good credit rating, because unfortunately to get a good credit rating you have to use credit if that's something that's going to be important to you in the future. But that's a controlled way that hopefully your budget won't get out of control. I try to impress upon my folks, like, don't use credit for credit. You don't want to use a credit card because you have no other options. But you want to, if you're going to use a credit card to rebuild your credit, use it on something you would pay in cash anyway, and then pay it off right away. Okay, I think in the interest of time, there's some other really good information here. On how to get the fee waived. There is a motion that's everything in bankruptcy court, initially at least outside the adversary proceeding, it's all forms. They're long forms, they have a lot of blanks, but it's all forms. And so there is a specific motion to get the Chapter 7 filing fee waived. So consider, and we kind of blended into this already. So considerations when filing bankruptcy. And so here's just, I think, what's kind of a fairly typical scenario that we see often. That Carol is recently separated from her abusive husband, is feeling overwhelmed by the cost of living alone on her Social Security check and a little bit of wages from a part-time job. Her husband has run up many bills in her name. She's now getting constant collection calls. She's worried about her ability to make her rent payment, and she wants to know more about whether bankruptcy is an option for her. So just to sort of kind of continue including you all in the conversation the best we can, what are things here that you would want to know more about from Carol about her situation that you think you would like to know in terms of helping her process this idea about whether bankruptcy is an option for her? What kind of bills and how much debt is she in? Great. That's exactly it, Caitlin. Has she filed bankruptcy before, and if so, when? Yep, Michelle, because that goes into whether she can file a bankruptcy again. You know, is it too soon? That kind of thing. Can she make payments on her rent if she doesn't pay her unsecured debt? Great. Pulling credit? Great, Chris. Yep, we always try to get folks to pull their credit reports so we can get a good picture. And again, with issues of coerced debt, and if somebody is, you know, if their abuser or somebody is using their information to get debt, they may not know all the debt that's out there. So it's really good to do that. What sort of assets? Exactly. As Caitlin points out, we need to know what sort of assets she has to know if we file bankruptcy, are we going to risk losing an asset, or are all those assets going to be exempt? A microloan program that might be useful for credit building program. Great. Helen, if you could just type in your geography, or is that National Network to End Domestic Violence, is that a national program? Or if there's a website or something that folks could go to learn more about that program. All right, good. Great, thank you, Helen. I need to make sure I cut and paste that too and save that. Okay, good. I think you all have a good handle on some of the issues. So as we talked about, collecting information regarding their financial situation. What are their debts? What are their assets? How do those assets fit into our exemptions? What are their goals here? Is Carol's short-term goal really focused on the rent payments? Are there long-term goals, you know, in terms of debt, but also long-term goals in terms of what do they want their life to look like 5 or 10 years in the future? Do they want to be able to buy a house? Are they going to need to refinance a house? What else is going to be going on that if we file a bankruptcy, the bankruptcy might either be useful for or may impair or delay that goal? And again, I think as we've touched on earlier, timing issues. So with collection activity, if you file your bankruptcy and there's been collection activity like garnished wages or garnished bank accounts within 90 days, you can usually get that money back. However, if we're at a day 100, then you can't get the money back. And so sometimes we need to look at filing really, really fast to get that money back and whether that's going to work. Or something like a foreclosure sale where we need to file the bankruptcy before the foreclosure sale to stop the foreclosure sale. Again, as I alluded to, stability of income. Well, I talked about the likely to incur additional debt, but I also like to look at stability of income. If I have a debtor who's not going back to work, is underemployed, and kind of things aren't leveled out yet, that's one factor I consider in filing the bankruptcy, because if they're underemployed or they don't have the income, there's a chance they're going to incur more debt. And we may want to delay the bankruptcy so that we can not have a lot of in debt incurred post-petition. And then also coordination with other legal proceedings And again, I'll talk about that intersection between the family law and bankruptcy court specifically in a bit. Does bankruptcy affect if going back to college to pursue a degree? Maybe. Private student loans are, those do often require credit underwriting or cosigners, and so bankruptcy may affect eligibility for private student loans. And I think, I don't remember if Persis is going to be talking about eligibility for student loans, but she might have some better insight into how the federal student loan programs are looking at bankruptcies. They generally have much looser underwriting requirements for federal student loans, and so she may know better if there's an issue there. The question about immigrants filing for bankruptcy. When I have somebody who is an immigrant and filing for bankruptcy, I always require them to consult with an immigration attorney because I am not. But what I generally get from the immigration attorneys is that bankruptcy itself is usually not going to be an issue for immigration status unless the bankruptcy then exposes tax issues, because tax compliance is essential for immigration, especially adjusting immigration status. But I am not an expert in immigration, and so I would say that if you have somebody who's considering bankruptcy who is an immigrant, especially if they're not on a permanent resident status, if they're on some sort of visa status or are undocumented, that they should consult with an immigration attorney, especially given these new public charge rules that are being proposed. I do think it's an area to be slightly cautious with. All right, so there's sort of the nuts and bolts of filing bankruptcy that's like the numbers. It's the math of filing bankruptcy. What do you own? What do you owe? What's your income look like? And how are you spending it? But the other part of filing bankruptcy that we really need to process with survivors is what is this going to look like for you, and what do you think about that? So it's important to talk about them. You know, how are you thinking about this? You know, do you come from an upbringing or a background where bankruptcy is kind of like the most awful thing you could ever do? Or do you come from a background where bankruptcy isn't that big a deal at all? Another thing to recognize is there is a significant volume of information that has to be collected and provided to the bankruptcy attorney to provide to fill in the schedules and all the documents necessary to file. And it is essentially the past 3 years of your financial life. And that past 3 years of financial life may be exceptionally tied up in the abuse that survivor has endured. And so to have to go through and relive all those financial transactions for the last 3 years may be exceptionally triggering and exceptionally traumatic for a survivor. And so we really need to acknowledge that, think about ways that we can make that survivor feel supported through that process, help her process all of the emotions through that process. Unfortunately, there's nothing that we can do to tell the bankruptcy court they don't get that information. She has to provide that information. But it's much more about recognizing that if the survivor wants to file bankruptcy, that has to happen, and how do we step through that process with her.
On that, really quickly, Karen, we know that a lot of survivors sometimes don't have access to some really important financial documents or information. Are there things that, have you seen that, and are there ways that you've gotten access or kind of worked around?
Yeah, you know, it's one of those, it's doing the best you can. So one recent example I had, I think we did her bankruptcy in the fall, maybe. That this particular survivor, she, when she was separating from her spouse, he had already gone to jail or prison. I forget where he was in the process. But he came and had his friend steal the computers out of the house that had all the tax returns on them. And you have to be able to present your tax returns in bankruptcy court, both because we need the information and because they want to physically see the tax returns. And so for that particular person, we had her sign a power of attorney with the Internal Revenue Service, and we requested a copy of her tax returns directly from the IRS instead of trying to get that computer back and try to get the tax return that was downloaded onto that computer. That's, again, where credit reports can be really useful, is that if they don't know or if they've forgotten to pull those credit reports and see what's showing up on there. So it's a little bit of being creative and looking at other ways to access information. Some holes are easily plugged. Some become a little bit more complicated depending on how much or how extensively the abuser has hidden information. But we do live in an information age where it's actually, it's easier now than it was 20 years ago to find the stuff. And there's different avenues to do it. So that, obviously that's good and bad, how easily you can find information. But for this purpose, we're generally able to work with folks to find alternative ways to find the information that was hidden. Now, obviously, there's a whole safety planning element here, too, about if you're starting to request documents, if you're starting to pull information, if you're starting to ask questions, that could, sort of tip off to the abuser that the survivor is planning something. And depending on the particular aspects of that individual situation, that could become a dangerous situation for the survivor and could, in fact, escalate the violence in some way. And so it's important before going through this process and before embarking on these things that you sit down with your survivor and you think through, okay, where is this relationship at? What has triggered this guy in the past? What's escalated the violence in the past? Are there things here that could cause an escalation? And if so, do we go forward now? Do we pause and try this later? Or do we plan, do some safety planning around this? And I always, come from a place that, she knows him best. And so often she should be able to help guide that conversation in ways, but sometimes it is useful to just even to make sure you ask the question so that she can think through what she needs to do to remain safe at this point. When someone has multiple abusive partners that have wrecked their credit, in a bankruptcy, everything's in, and so you do have to, and this is important for safety planning, if there is a co-signer on a debt, you do have to give them notice of a bankruptcy proceeding. So if a spouse or a partner is co-signed or joint on the debt, they're going to get notice of the bankruptcy. And so it's important to think through, is that an okay thing to happen? Because there's not a way around it. And is that, okay, we file the bankruptcy now and it will be fine, or do we wait 6 months and maybe that will be okay in 6 months or down the road? If they haven't filed tax returns in the last 3 years, that is going to be an issue, especially in a Chapter 13 bankruptcy. A Chapter 13 bankruptcy, the court cannot confirm or put into place that bankruptcy plan if there are unfiled taxes. So once in a while I filed an emergency bankruptcy without taxes filed and caught it up. The best practice would be to get those tax returns filed and get clean with the IRS before you move into bankruptcy court. Now, if they aren't filing because they're under the limits for filing, they only get SSI, then in those cases they don't need to file a tax return just for the sake of filing a tax return. They can just, in my area, I just do an affidavit for the bankruptcy court that just says their only income is SSI, they're under the filing limits, and they didn't need to file. Is waiting 6 to 8 weeks after seeking treatment on the severity of the trauma an option? Absolutely. This goes into timing considerations. There might be a situation where we do need to file really, really quickly, and so waiting may be a problem, but for most kind of run-of-the-mill Chapter 7 filings where we're really just looking to clean out credit card debt, or not dealing with a foreclosure or something, then timing can be very flexible. It's a very individual consideration. Alternatives to filing bankruptcy. Again, there might be reasons not to file, or the survivor decides just filing is not for her. Are there other ways to solve these financial problems? And it can look like settling with creditors. Theoretically, we're coming into tax refund season. I think between the shutdown and the new tax laws, this is going to be a very confusing tax refund season. But sometimes we can use those tax refunds to settle debts, to get rent paid, to get folks into a more stable financial place that could either give us time to postpone a bankruptcy or can kind of solve the issues that are leading somebody to want to file bankruptcy. We might be able to work with the IRS if it's a tax debt, work with the student loan people to deal with the student loans, and maybe if we do those things, everything else will domino okay. The same thing with mortgage foreclosures. There might be alternative ways to deal with the mortgage company, to do a loan modification or do something else that can then keep you out of bankruptcy or make a bankruptcy unnecessary. There's also a certain number of debtors and survivors that are what are called judgment proof, or sometimes we call it collection proof, that their only income is Social Security, or they're working, they're not working a whole lot, they're earning less than like $200, $220 a week, they can't be garnished, there's really nothing that can be taken from them. And so sometimes those folks, especially if working through the bankruptcy is going to be really traumatizing or really difficult from sort of a getting all that paperwork pulled together standpoint, a lot of those folks were just like, look, they can't do anything to you except call you, don't answer your phone, and you probably don't need to file bankruptcy because it's not going to really do a whole lot for you. I kind of have a group of senior citizen clients who are all sort of in this thing that they call me about every 6 months and say like, hey, I got this letter, or I'm getting these phone calls, and we do a quick review of the situation, and I'm like, I still don't think you really need to file, and they're good for another 6 months. I also warn folks to be aware of the for-profit debt settlement industry. If any of you have happened to be at home for daytime TV commercials, you've seen lots of commercials for debt settlement companies that offer to fix all your debt problems for a low, low fee. I think those are really attractive to folks who are dealing with debt loads that they can't afford, who find bankruptcy scary or disadvantageous for some reason, that they don't want to do that. Their abuser has told them if they file bankruptcy, they'll take the kids or crazy things, and they think this might be a viable alternative. Most of these places are very expensive. Most of these places don't do very good work. I've had a lot of clients who I have lost a lot of money to these places, and we end up in bankruptcy anyway. So just to be on the lookout. Their advertising materials are very good. Their service is usually not. Okay. The intersection between family law and bankruptcy. We have a quick poll here about what best describes your situation. Whether you're able to kind of handle bankruptcy issues in family law cases, do you have someone to go to, or or you feel like you don't really have anything to help deal with this intersection. Oh, the number 4s are so high. I don't like that it's so high. All right, so it looks like a lot of
you here for those kids, or if you have any details, share in the chat kind of your experience, so maybe we can either address it or follow up with some more on that later.
Yeah, I only have 3 answering number 1, and I'm pretty sure I know at least one of those people, if not 2. So there's obviously a significant overlap between bankruptcy and family law. And so here's, I think, kind of a typical situation that we see a lot, at least in my office, about so Maria decides to file for divorce, is seeking primary custody of their children, that her husband be required to pay child support, and that she be allowed to keep the house they own jointly. In response, he decides to file bankruptcy. And he then claims that she has to drop the divorce case because of the bankruptcy, that because of the stay, she can't move forward. He also says that she has to file with him, that she can't avoid it because they're married. And so she kind of wants to know what her options are at this point. And I can imagine Maria's probably feeling like really scared and really overwhelmed that she finally took this huge step to file for divorce, and now he's trying to thwart the whole thing and tell her she can't do it. So I kind of want to know what your thoughts are, your initial, like, what do you think you need to know? What concerns do you see? What do you need from Maria? All right. So I thought you could not file for bankruptcy as there is a pending divorce case. No, you can file bankruptcy. There's no there's no limit on filing bankruptcy, even if there's other things pending. It's just what happens with those other things pending become the question. It may be ill-advised to file bankruptcy during a divorce case, but it's not in any way forbidden by the bankruptcy code. Tempest, again, my housing person, indicates there's a nonprofit in a nearby city in Chattanooga that helps victims of domestic violence with credit counseling and bankruptcy. We don't have a partnership with them at that time. I think, Tempest, I'm going to encourage you to go make some friends. I think I need to make some friends with them, too. Local law schools sometimes have free bankruptcy services. Yep. Child support must be paid even if bankruptcy is filed. Absolutely, Lourdes. That is, in fact, true. That's a domestic support obligation, and we're going to talk about that. Okay. One thing that you'll need, file adversary to seek denial of discharge for coerced debt. That's fascinating, William. I think I'm going to actually make sure I even write a Post-it note because I want to come back to that. I want to unpack that. Adversary coerced debt. Hey, William, can you type in where you are? I love that idea, and I may want to connect to you, Texas. Okay. Yeah, so one thing you may need to get is the actual bankruptcy filing, because while Maria may get notice of the bankruptcy filing, when the bankruptcy court sends out the notice of bankruptcy filing, it's just like a 2-page, 3-page notice, and it doesn't have all the detailed financial information that her husband is going to have to file with the bankruptcy court. And it can be quite fascinating to see what people tell a bankruptcy court versus what they've been telling the family court. And so another reason you need to make a friend with a bankruptcy attorney if you do not have one already is because you may want somebody to get on what's called PACER, get onto the electronic filing system and pull that information for you. We found many circumstances where, amazingly, the financial situation disclosed to the bankruptcy court was far different and made paying child support look a whole lot different. So it can be a useful piece of information. Okay, so one of the first concerns is if she has filed, if he has filed, if the abuser has filed bankruptcy, how does the automatic stay now affect the divorce case or the family law case? And so this is the portion of the bankruptcy code that addresses that issue. There is an exception to the automatic stay. That means that the automatic stay does not apply, and the court case can proceed at pace without having to do anything extra in the bankruptcy court. That exception applies to establishments of paternity, establishment or modification of an order for domestic support obligations, so for child support or alimony, for actions involving child custody or visitation, for the dissolution of marriage, so the actual you are hereby divorced, although the stay may still apply to the extent that we're looking at a division of property that is potentially property of the bankruptcy estate. Then there is an exception for actions involving domestic violence. Those are probably your orders of protection, personal protection orders, whatever they're called in your state, and any ongoing collection of domestic support obligations. So ongoing child support collection, either by the other parent or by whatever governmental agency may be involved in that in your state. So going back to Maria's situation, she can still ask the court to be divorced. She can still ask the court to determine the custody and parenting time or visitation for the children. She can still ask the court to order him to pay child support. The only really big thing that's going to get hung up by his bankruptcy is what's going to happen with the house. Okay? But overall, probably the 90% of her goals in that divorce case can still be addressed and still be worked on despite his bankruptcy. Just to clarify, a domestic support obligation does have a kind of fancy bankruptcy lingo, and it does include both debts owed to the other parent as well as debts that have been assigned to a governmental unit. So say your client was on TANF and the child support payments were assigned to the state. Those are included in domestic support obligations. It includes alimony. And so when you look at the payments that are being made to a spouse or now former spouse, and whether it's a domestic support obligation, the bankruptcy court is going to look at what is actually going on, not what we've titled it. Because sometimes, as we know when we've done family law, sometimes you're seeking payments, but they're not so much as alimony as they are for other things. And so the question is going to be, how are those other things being treated? And are there going to be domestic support obligations, which will not be discharged in bankruptcy, or is it something else that might be dischargeable in the bankruptcy? So for example, when a debtor's obligations to make direct payments directly to a third party and to hold the former spouse harmless from those debts might be a non-dischargeable support obligation, but the bankruptcy court can look into what was the intent of the parties or the state court, what was that obligation, and a whole lot of factors. So if it's not a straightforward alimony, but it's he has to pay the car loan for her, that's going to get a little bit more complicated. It's going to become a very fact-based inquiry. A marital property division. So this is not alimony, but other property settlements that these are generally not discharged in a Chapter 7 bankruptcy, but might be dischargeable in a Chapter 13 bankruptcy. So if you've got folks who have a more complicated financial situation, and he's supposed to pay, so say he ends up with the house, say Maria's husband ends up with the house, but he has to pay her $20,000 of the equity, he files bankruptcy. Does he still have to pay her $20,000 as bankruptcy? And the question is, maybe. If he files a 7, it's a marital property settlement. It's not dischargeable in a 7, but if he does a Chapter 13 with a payment plan, it may be. And this is the point where you get your survivor to an experienced bankruptcy attorney to unpack what is happening here and if they're going to need to do something. So there are, when a survivor is notified that her former partner or soon-to-be former partner is filing bankruptcy, every bankruptcy involves a meeting of creditors, and the survivor could choose to attend that meeting creditors or send an attorney on her behalf to sort of see what's going on. It can be very useful to get a lay of the land and what's going on there. In some situations, depending on what he is doing and what kind of, whether we're working with a marital settlement agreement versus a true domestic support obligation, it may be necessary to file a proof of claim. We may want to file an adversary proceeding. If he's saying this is not a domestic support obligation and this is chargeable, but we're looking at it and saying, no, this is a domestic support obligation. This was supposed to be for the support of the spouse, and you may need to file an adversary proceeding. Now, this is kind of where I want to go back to William's comment out of Texas about coerced debt. And I think this actually flips the other way. And I find this is great. So say we represent the survivor who has filed bankruptcy. No, I take that back. So let me think this all the way through. So if the spouse, if the abuser files bankruptcy and is seeking to discharge debt, then we would file an adversary proceeding saying he lied to get that debt, and therefore it should not be discharged. I don't know, William, if you've ever tried that, but I think that could be a really interesting way to make sure that the abuser remains on the hook for that coerced debt and remains on the hook in the bankruptcy court, not just the family court. Yeah, I think, we'd have to look at issues of co-signers. I would love if somebody, and I don't think we could have time today, we're quickly running out of time. If somebody has a case like this, I'd love to work it through with you. But the real point of this slide is there are things the survivor can do to make sure that she knows what's happening in the bankruptcy and to protect any claims she may have in the bankruptcy. And so we can inform her of those things and help her make the choices about what she wants to do and how she wants to do it. I think I'm going to skip this chat slide in favor of going into the next session because we only have 10 minutes. So here are some things in terms of moving forward and how do we move this conversation about the intersection of bankruptcy and domestic violence survivors forward. All right, Diana, I've got you. So here are some ideas that I had and some colleagues have had that I wanted to share with you. First of all, talking to bankruptcy attorneys about the intersection and about how they can use trauma-informed advocacy in their own practices, and how to work with our survivors, understanding and getting knowledge about how our survivors may act differently in situations and may need something differently than the clients that they're used to working with. And so then also partnering with them so that we can develop a good pool of bankruptcy attorneys who are experienced with working with survivors, who we know that if we refer our survivors to that bankruptcy attorney, they're going to be in good hands and will work well with them. Again, and if you've ever heard me talk, you've heard me say this, about breaking down the silo of different practice groups in your own program. Many of our programs, there's a family law unit, there's a consumer unit, and they don't always talk well. And so I really want to encourage folks to talk to the other practice groups and other specialties in your program and to see all these intersections. If you're in the middle of the divorce, talk to your bankruptcy attorneys about how can we make these things work together. Are there things I can do in the divorce, or are there things that need to be done in the bankruptcy to best advocate for our survivor? This kind of goes up to the earlier question about how do we pay these filing fees? It's really expensive to file bankruptcy. And not a lot of people are going to be eligible for fee waivers, or they're going to need $20 to file to get their credit counseling course. And so, depending on your organization, is there a way to establish or maintain some sort of fund to help with the costs of bankruptcy courts? Another thing is advocating with your local bankruptcy court to implement a local rule or a local procedure about implementing that section of the code about non-disclosure of address, so that when you need to use it, the clerks aren't trying to figure out, like, well, how do we do this? But to sort of already have a procedure in place so that when you need it, it is there. All right. And I'm seeing in the comments, Diana, I do have your request. I will think that through. My email is in the end of the presentation if you want to email me about your request for more on marital property division. Someone mentions pro bono lawyers. Yes, I think this is a great way to involve pro bono lawyers in your practice. Chris mentions the California program about protecting survivors' addresses and documents. The bankruptcy court doesn't have to, the bankruptcy court requires disclosure of the address unless it doesn't. So the state programs may not work well with the bankruptcy court. The bankruptcy courts need to come up with their own thing. And they have the authority to do so. So we want to make sure that they have thought that through, and then that procedure is available for folks. Tempest asks, how easy is it to actually get the court to work with advocates? I think that's, how is your local bench? This is on my radar to discuss with my local bench. I am really fortunate. I have my chief bankruptcy judge, I think, is a really great judge, and this is on my list of ideas to talk about with him. And I think I will certainly get a sympathetic ear about how to handle this. I think different courts are going to work with you differently. It's like all courts. Sometimes you've got a really good judge. Sometimes you don't have a really good judge. And so it may be, wait for somebody else to get appointed. But they can also, again, I try to collect what's happening in other areas, and so we can work about that. Yeah, small town courts can be a little difficult. I mean, the bankruptcy courts are a federal court, so that can sometimes be useful with getting folks on board. Yeah.
And one thing that's been talked about in, sorry to interrupt, Karen, just on that note, one thing that's been talked about in previous webinars with kind of a similar question, and we can provide more information here, is sometimes kind of gathering information on like the extent of the problem and the type of concern can be convincing, particularly with kind of hard to reach or convince benches or other systems. And so that's why we've done, if you want help in kind of thinking how you might document the need on like a broader level, we're happy to talk with you more and strategize ways that you might present that, whether to the court itself or to some allies or partners to try to kind of make the case in a different way.
Good. And Tempest, I think you're my one in Tennessee, and I want to say there's a really good trustee, bankruptcy court trustee in Tennessee, that maybe that would be a way into that system as well. All right. Well, we are getting pretty close to the end, and I don't want to cut off conversation, but at the same time, it is probably time to start wrapping up. So I don't know, Sarah, if you have some additional comments, and I know you have some closing items that you want to go over.
Sure. What would be great, or what we thought we'd leave you all with, because first, thank you so much for sharing your questions and strategies. If you have remaining questions for Karen, please type them in the chat now, and we'll make sure to address them and connect you all of that afterwards. But I'd like to do a round robin kind of a closing thought with Karen, Erica, and Yvette, just to kind of link what some of you have been talking about already in the chat, how we need to think about the ways our organizations work, potential partnerships, navigating and changing systems. So I don't know if Karen, Erica, or Yvette, who wants to kind of start with like a final word or reflection on this that links it to this macro level. That might be a great thought. And then again, if any attendees have their own thinking there, that would be wonderful to hear as we think about ways to follow up, share more, and engage more in the future.
This is Erica. I have a couple of sort of big picture thoughts that seem to have bubbled up during folks' contributions through the call today. One is just the fact that there are, one of the persistent problems that folks are facing, of course, is that in addition to the sort of economic costs resulting directly from abusive batterers, in the form of coerced debt, folks are often sort of saddled with the cost of having to navigate the court system and trying to access justice. So for me, that feels like an issue that is ripe for lots of strategizing amongst folks in different places, and it seems like it's a opportunity. I know that one of our guidebook chapters in particular was focused on court-related barriers facing indigent survivors of domestic and sexual violence. And so sort of what are those strategies so that folks are not facing additional economic hardship and trying to access the relief that they need. Another theme, that came up in a couple of different spaces is around partnerships. And I know certainly, it seems like we're hearing a lot about the need for building partnerships between family law and bankruptcy attorneys. And so sort of thinking through what are the ways that we can formalize those partnerships, or at least create very intentional, steps for cultivating some of those relationships so that they're in place and survivors' needs are met. And then the third point that I would just raise is around the need for partnerships between non-lawyer advocates and lawyers, both of the family law and the consumer law variety. There's so many areas, whether it's around documents that we talked about or around safety planning, where there are just very fertile ground for advocate-lawyer partnerships, which, are beneficial on so many different levels in terms of survivor safety, in terms of efficiency of resources. So those are a couple of the things that I have heard throughout the course of today's really robust conversation.
Hi, this is Yvette. First I want to say, Erica, I'm glad you brought up the non-lawyer advocates piece, because that was one thing I was going to note. But also I wanted to mention that, whether there are examples of this that can be talked about now or just emailed later, I'm curious about whether there can be policy changes made within financial institutions that would at all be helpful, sort of like how, maybe people could try and change policies in their local court to make things easier for future individual advocacy. Like, are there any advocacy possibilities with the financial institutions? So I'd be curious whether anybody has ever tried that or whether it's been helpful.
Yeah, that'd be great to hear. So please share all of that. Patricia just shared an evaluation link, so I encourage you to respond, because we really value that, and there are multiple opportunities for you to share what you're doing, and also what you're doing, what you're seeing, as well as things that you need going forward. So thanks for that. Karen, I might give the last word to you. Do you have like a final reflection or thought as we close here?
Yeah, no, I'm really grateful for all of you for thinking this is important and getting on this call. Again, this is, other than the guidebook chapter, this is kind of our first foray into really looking at this, the bankruptcy intersection. And so I would just really encourage you all to give us your feedback, to reach out to me or Sarah or Erica or anyone at CSAJ about both what you thought of this webinar in particular, but also what else do we need to do in this space, and where are the gaps, so that we can really address them. Yeah, but thank you.
Thank you, absolutely. Thank you so much for sharing all this, both broadly and deep into the intersection with family law. I think it was a really great presentation, and very centered in how complex and how layered it was. That's what stood out to me. Taxes, student loans, immigration status, all of these things come into play, and these are the really important questions that we ask, and how we navigate these issues in partnership with survivors and each other. So as we close, just a note that we'll share all of this, and there are a whole bunch of other slides that we're not going to get to, but I do want to note again the evaluation link, remind you to join us in 2 weeks for the student loan webinar that Persis, you will be doing with us. And again, if you're interested, or if this has spurred any thinking, let us know what you're doing in this area. And then finally, we don't have a slide for it, but we are planning some what we're calling peer exchange TA calls. And I think that the issue about coerced debt and bankruptcy that came up is really ripe for deeper discussion. So stay tuned, and we'll share more information about when and where, and any topics on that, and would love to engage with you all in that process. And then finally, go to our website and download previous webinars that really fit nicely with all of this, and many other resources. And if you can't find it, let us know, and we'll point you to it, and are happy to hop on the phone and talk through things as well. So thank you all so much. Karen, thanks a million. You're great, and you made it with your talk, so I'm really appreciative of you pushing through. I know it's hard, and thanks, everybody. Hope you have a great day.
Thank you. Take care, everyone.